Good morning. Welcome to today's webinar on updates and answers on redistricting and reweighting county voting systems. My name is Mark Levine, and I'm the Deputy Director of your New York State Association of Counties. We appreciate you taking time to spend with us today on this webinar. Well, NYSAC NYSAC has been getting several questions, continuing questions on redistricting and reweighting based on the 2020 census. This is the third of a series of redistricting and reweighting voting system webinars and workshops that we've done since September. We are pleased to offer this. These are our go-to experts, and I'm honored to introduce them to you this morning. The first is Gerald Benjamin, the founder of the Benjamin Center Emeritus. Gerald Benjamin joined the New Paltz faculty as an assistant professor of political science in 1968 and achieved the university's highest rank in 2002 when he was appointed as a distinguished professor. Unknown caller. As a distinguished professor by the SUNY Board of Trustees. He served as chair of the Department of Political Science, presiding officer of the faculty, and dean of the College of Liberal Arts and Sciences from 1996 to 2008. Jerry is also a former chair of the Ulster County Legislature. Jeff Weiss is an adjunct professor and senior fellow at New York Law School and the New York Census and Redistricting Institute. He is now working on his fifth redistricting cycle. In past years, he served as redistricting counsel to 5 state assembly speakers and 4 state Senate Democratic leaders. He currently serves as counsel to the Assemblyman Robert Rodriguez, the Assembly's Lat 4 chair, and he is the co-editor and author of the National Conference of State Legislatures recently published 2020 Redistricting Red Book, a comprehensive handbook on the census and redistricting processes. He also served as counsel to the last 2 New York City Council redistricting commissions and to numerous state and local governments across New York State and the nation. Jeff was integral to the crafting of the law, that the most recent redistricting law that we'll be talking about today, and that every county is working under during their redistricting process. Josh Simons is a senior research associate for the Benjamin Center. He specializes in geographic information, or GIS, redistricting, shared service analysis, and data visualization. He holds a BA in political science from SUNY New Paltz, magna cum laude, and a Master of Public Administration from Marist College, and is a member of the Pi Alpha Alpha Honor Society. His recent projects include the creation of charts and diagrams for the Orange County Citizens Foundation 2015 report card, the creation of an online interactive map and website to display information about vacant properties in the city of Newburgh. He is currently working on the creation of an online interactive map for the Greater Walkway Experience and is a consultant for the City of Poughkeepsie Charter Reform Commission. Jeanette, I turn to you now. Are there any housekeeping announcements to make before we turn it over to Jerry Benjamin?
Thanks, Mark. Just 2 really short notes. We will be recording this program and posting it with a PDF of the slide deck on NYSAC's website under the Education tab. All you need to do is go to nysac.org/webinars. If you have questions during the program, we encourage you to submit them in writing by referring to your dashboard and clicking on the Questions tab. Type in your question at any time during the presentations, and we will get to those questions during the Q&A at the end of all presentations. Thanks, Mark.
Thank you, and we're going to try to get through the presentation as quickly as possible because we know there are several questions out there. The presentation will answer some of those questions, but we also want to give time for our participants and our audience to ask questions that may not be answered during those presentations. So without further ado, Jerry Benjamin. Jerry?
Well,
I think that, good morning, everyone. I know there are some old friends in the audience and some acquaintances, and I'm happy to be here with you. I think we're going to start with Jeff, though, because this was the top of the list of topics that people have been asking and calling about. Jeff?
Okay, well, I'll go first, sure. This is Jeff Weiss from New York Law School, and I'm going to take a few moments to give you an overview of the law and some practical ideas that you should be mindful of as you are working on your county redistricting processes. Now, what we see here on this slide are the basic governing laws for redistricting in New York. The first one, of course, is equal population, that all districts need to be equally populated under the Supreme Court precedents going back to the 1960s, Baker v. Carr, of one person, one vote. And I'll go into that a little bit more in depth in a few moments as it applies to New York State and the new statute. Secondly, we have the Federal Voting Rights Act, and the Voting Rights Act requires that in situations where you have high significant levels of racially polarized voting, and you can create a majority district of one racial group, whether it be Black, Hispanic, Asian American, etc., then you would be required to create a majority minority district. That's under Section 2 of the Voting Rights Act. We also have the New York State Municipal Home Rule Law. We have county charters to deal with, both for this year and beyond. And we have the new law that amends the Municipal Home Rule Act to apply to all local governments across New York State. I'll also add the U.S. Constitution's 14th Amendment has the Equal Protection Clause bans racial gerrymandering, and that's where you pack too many minority voters into one district, denying minority voters the opportunity to impact the outcome of an election in an adjoining district. And you might be reading today's newspapers over what happened in Alabama yesterday at the U.S. Supreme Court, where allegedly one congressional district was overly packed as a racial gerrymander. The Supreme Court set the challenge aside to hear the case so that the new map enacted by Alabama will be used in this year's election. The next slide, please. Okay, so just as a quick review, we have, I think, 16 county boards of supervisors, 40 county legislatures, 23 charter counties, and 17 non-charter counties. Every county, as well as every city, every town board, every village board that elects legislators based on districts needs to redraw their lines or reconfigure the weighted votes before the elections either this year, although I think most governments that have elections this year have completed their processes, or for next year's election. We have either single member districts or weighted voting districts. Josh will go into that more in depth, and that's where each member has a weighted vote based on population. Next slide, please. Okay, in New York State recently, in the last few years, we have had two major Section 2 Voting Rights Act cases. I wanted to highlight these because they could play into what happens in your county if you have a large minority population. Just last year in Rockland County, in the case of Corvo versus East Ramapo Central School District, the school district was found to have violated the Voting Rights Act by diluting the voting strength of Hispanic voters for a school board. And the federal district court in Rockland County ordered a reconfiguration of how the township elects its school board members. And then 2 years ago, in the case of Flores versus Town of Islip, we had a 4-member at-large town board, and there was about a 33+% Hispanic voting age population that grew over time with the population demographic trends on Long Island. That at-large scheme denied the Hispanic voters the opportunity to elect their preferred candidates. And in a consent agreement, the town agreed to create 4 single-member at-large districts. As a result, in last November's elections in 2021, one Hispanic majority district did in fact elect a Hispanic candidate. And I am guesstimating that over the course of the next few years, you might see more challenges to any at-large schemes in New York State, and especially take a look at your school districts, but this could also happen at a county level. You know, there is some talk. Onondaga County recently enacted its county legislative redistricting plan. Although I haven't seen it yet, there's been some talk in the media of a plaintiff group possibly suing the county over the failure to maintain or create a minority district of one race. Next slide. Okay, so these are the old municipal home rule law criteria. This applied to all non-charter counties. You had population equality, that no towns except those that comprise 110% of an ideal district population could be divided. The law called for providing fair and effective representation for people of local governments organized in political parties, and that districts should be of convenient and contiguous territory in as compact form as practicable. So this was the law that applied to every non-charter county up until the enactment of Chapter 516 last year. One note on the word practicable. Practicable means if you can do something, you must do something, as opposed to, let's say, compact form as possible. So you need to be, wary of what is practicable, what you can do, or as opposed to what you might do. So practicable should be seen wherever it's used as a mandate and as a directive. Next slide. Okay, in 1991, I'm going to readjust my screen so I can see this. Oops. Hold on. Am I still connected?
Yes, you are.
Okay, I just lost my screen, but I have my slides in front of me, so I'll continue. Just 1 second. Okay, so in 1991, the Westchester County League of Women Voters challenged the county's legislative redistricting law because it didn't follow the state guidelines contained in the municipal home rule law for non-charter counties. And 30 years ago, the appellate division held that the county operates under a charter form of government and its reapportionment plans are adopted pursuant to its charter, not municipal home rule law. So charter counties were found 30 years ago, they were not required to follow the state MHRL standards. Assemblywoman Amy Paulin, who was then president of the League of Women Voters, was elected to the Assembly during the 1990s, I believe, or in 2000, and she introduced legislation to cover charter counties so that statutory provisions for redistricting would be uniformly applied across New York State. And she fought for that legislation for about 20 years, and it never succeeded until the leadership in both the Senate and Assembly last year decided that the bill, should move forward, that it would pass, and decided also to bring the criteria first developed in the Paulin bill in the 2000s more up to speed. So next slide. So the new law that Governor Hochul signed in late October, it's Chapter 516 of the laws of 2021, create new ranked criteria. So that avoids trade-offs. When criteria is ranked in particular order, it means you have to follow the first criteria, then the second criteria, third, fourth, fifth, and so on, so that as long as you accomplish meeting the goal of a higher criteria, you're less bound just by practicalities for complying with the lower criteria. So the most important change in the law, the first criteria, is that the population equality has to be as near as practicable within 5% from the size of the smallest to the largest district. That means a district can be minus 2.5% or plus 2.5% over the ideal district size per district. And you, of course, determine that by taking your county total population size divided by the number of districts. That gives you the ideal population goal for each district, and you can go above or below that by 2.5%. You can go above 4%. You can go below 1%, but you cannot exceed 5% overall. And then if you have multi-member districts in your county, then you've got to re-equate those based on the weighted voting that Josh will go into. The second criteria is that the plans cannot intend to or result in denying or abridging minority voting rights. That is very similar to the Federal Voting Rights Act. Districts must be contiguous, meaning you should be able to go from one part of the district to another and not leave the district. Districts must be compact, and I think compact as practicable, meaning that there are mathematical models out there that courts will look to see if a plan that's been enacted is as minimally compact as possible, or whether the plan might be distorted to the degree that a better plan could have been drawn. Then continuing with the criteria, districts cannot favor or disfavor incumbents, political candidates, or parties. That's the gist of the lawsuit filed in Steuben County against the new congressional plan approved by the legislature last week over partisan gerrymandering. You also, in adjoining districts, can consider the existing cores of current districts, of political subdivisions, and communities of interest. I'm going to go into that in a little bit more detail in a moment. Now, also a very important criteria that's new is that no village, city, or town, except those having 40% of a full ratio of a district, can be divided. So in essence, if you have a village that can contain by itself 40% of a full district, less than that, then you can't divide villages. So the goal here is not to split, cut and dice small municipalities to round out the populations for other districts. And also there's a criteria that districts must be formed so as to promote orderly and efficient elections. That means essentially you want to provide at least a month's time for your Board of Elections in the county to be able to realign the election machinery to comport with the new districts, not provide them with just 2 weeks as the boards of elections have right now to rush through the new congressional and state legislative lines for petitioning to begin on March 1st. Next slide, please. Okay, now on communities of interest, because this could be a tricky criteria because it's not defined in law. When you're balancing other traditional criteria, communities of interest are usually referred to as COIs, usually rank below population equality and minority voting rights, and often above all the others. Here in the new law, it's kind of in the middle with other criteria. But when you develop a community of interest, they're basically either subjective or objective based on socioeconomic, religious, educational, medical, where people live, how people identify as living with each other, and how they want to be joined together to form one district. A community of interest can camouflage partisan gerrymandering. One of the arguments that will probably be made in the case challenging the congressional plan was that the state will defend by saying, well, we join together in our districts communities of interest as suggested in the criteria. The plaintiffs are going to argue that communities of interest was not the reason these districts were created a certain way, but that it was done for partisan purposes. So you have to be able to know what your community of interest is, whether it's partisan gerrymandering in disguise, or whether it's a good faith effort to create a district where people live, identify, and associate with each other. Also, when you hold public hearings or receive public input, you have to ask, are the communities of interest being presented to you too subjective on the part of the presenter? What might be a community of interest to me where I live in Nassau County might be entirely different to someone else that lives a few blocks away from me and says, no, Weiss doesn't know what he's talking about. That is not a community of interest. So you need to know how to weigh things. And communities of interest can also lead to strangely shaped districts, which then conflicts with your compactness score. So you want to make sure that you're judging what communities of interest are very objectively and fairly. And you also need to consider when communities of interest might become more important than villages, towns, what's unincorporated areas, because people often identify by school districts, which might cross village or township hamlet lines. And for the longest period of time, districts have often been drawn to comport with keeping your villages, towns, cities intact. So just be mindful of the of the conflict that could occur between communities of interest and other criteria. Next slide. I'll be wrapping up in a moment. Now, also in communities of interest and race, for those of you in counties that have large minority populations, just be mindful of the U.S. Constitution's 14th Amendment Equal Protection Clause ban on to avoid packing of minority voters that could lead to racial gerrymandering. So if plaintiffs come in and say, we have a whole series of communities of interest that follow a highway for 50 miles, you want to be very cautious that you're not creating a district that packs packs residents, and also that leads to creating more minority residents than necessary to elect a preferred candidate. And by the way, for those of you that do have significantly high minority populations and have witnessed or are concerned about whether you have racially polarized voting or not, it's always best to retain the services of a qualified political scientist or expert who can run the numbers for you, because there's no gray area. It's not a guessing game. You either have a requirement to create a minority district or you don't under Section 2 of the Voting Rights Act. You also want to make sure that race is one of several factors being used. You always want to avoid race being the predominant factor. That's where race overrides every other factor. You are required to use racial data, especially if you have a Voting Rights Act or minority voting situation. There's some talk that race shouldn't be used in redistricting. I don't go along with that. And again, I have my last point here to use a racial voting analyst to determine whether you do or don't have to create a minority district. On my last slide, I provide my email address and my phone number, so I'd be glad to work with anybody that has a question after this call. I'd be glad to work with you. So thank you all very much.
Okay, again, good morning. We're going to try to go expeditiously through our slides so that we can leave more time for questions. I have a couple of footnotes to elevate, not the importance, but draw your attention to some key points that Jeff made. First, the state has said in this new legislation, notwithstanding Court of Appeals decisions, this is our intention, that this law apply to charter counties and non-charter counties alike. So it's a legislative intent that's specified as preemptive of counties. But this is not, this may be challenged, so you need to watch this going forward. It's essentially a challenge to home rule. Second, in the law, the state says, here are the criteria you have to use ranked. And the ranking is going to be important if litigation arises or challenges arise based upon a criteria lower in the ranking against one higher in the ranking, of course. And the relative importance of the rankings will be tested. Third, the state in the law is telling you the criteria you have to use, but not how to do it. They're not telling you you have to have a commission. They're not telling you they have to have a special committee. They're not telling you you have to have bipartisan approach. Those are local decisions on process. The law talks about criteria, but doesn't talk about process. Okay, let's move along relatively quickly. We're going to be talking about, so here are the guiding early decisions, one person, one vote. These, Jeff talked about these. Next, please. Most counties in New York are historically governed by boards of supervisors. boards of supervisors, we used to call it extra duty in the Army, were put the supervisors augmented in charge of the counties, as well as their primary job, running with colleagues the towns. The towns weren't of equal population, so the government structure for most counties in New York was automatically unconstitutional with these decisions. Next slide. This is demonstration that Professor Benjamin gets his slides in the wrong order. I'm sorry. Okay, so boards of supervisors comprised of supervisors of each of the towns, augmented by additional supervisors elected from wards within each city, because of course cities are not overlapping towns as might be the case with villages and towns or school districts and towns. Next slide, please. Some counties with charters were already empowered to respond to the federal constitution requirements in their charters. But state legislation, which Jeff summarized, was required to empower most counties to adjust their governance structures. That is, most counties were governed by boards of supervisors. Two major alternative approaches arose. One, weighted voting, retaining the board of supervisors and all the boundaries of the towns and adopting a weighted voting scheme, or replacing the boards with legislatures and creating single member districts of substantially equal population, or combining towns, maintaining their boundaries, and using single and multi-member districts to assure the citizens were equally represented. Also, periodically altering the size of the legislative body was used to maintain compliance with one person, one vote, which also had a partisan motivation. In Ulster County, that was certainly true. Next slide, please. This is my count of counties. If mine and Jeff differ, somebody's right and somebody's wrong by one or two. So we'll have to check that and ensure that you have a right number. Those with county legislation must consider redistricting if redistricting is needed and if redistricting is necessary. If you don't have a county legislature, you have to look at the weights to determine that they still leave you in compliance with federal and state constitutional and statutory requirements. But you don't need to adjust any boundaries. Next slide, please. This is an example from Columbia County's most recent weighted voting scheme. You can see the range of votes that each town has been determined will be exercised by that town supervisor or by each sub district in the city by that city's members of the board of supervisors. Next slide. Now I'm going to use this as a transition slide to get to Josh. I presume that's okay with you, Josh?
Yes, absolutely.
In some circumstances, allocating weights to representatives entirely in proportion to population excludes some of them from effective participation and guidance. So this is important. The proportionality is not the population, it's a power equalizing approach. A simple example, if one of Columbia's towns had more than half the county's people, which of course it doesn't, and it had more than half the weighted votes, it could run the county without participation of the other towns. So you want to avoid a formula that automatically excludes a town and its citizens from participating effectively in governance. This is why we do power equalize. Josh, okay?
Yes, yes, sir.
Okay, so next slide and Josh will take it up.
This one's actually yours, but
Okay, well, I'll summarize. Proportionality in weighted voting has been determined by the New York courts to be power equalizing. It's not sufficient to weigh relative to the population. This is a case that was which was done by Nassau County and overturned. Weight must be based on the percentage of time a representative may comprise a part of a potentially winning coalition. This is called the banzaf index after an attorney who also was good at math, who wrote a lawsuit and wrote this lawsuit and brought the court to determine that power equalizing was required. There's a reference here to a video that I think is pretty clear and shows you how the banzaf index is calculated. Okay, let's see what happens next, Josh.
Okay, I'll just take it from here. So
Okay.
initially, when a weighting voting system, you would basically just adjust your weights based on the population proportion, right? So if you had 20% of the population in your district, you'd have 20% of the vote. The issue with that is that in a weighted voted system, in order to reach a majority, you're going to need to form coalitions to reach that majority. Now, leaving aside any sort of partisan, influences on this, you can have a weighted voting system whereby you have different classes. You can have basically dummy districts where the weight isn't sufficient enough to actually sway an outcome in any of the coalitions that could be formed. You could have what's deemed a dictator, which means basically any coalition that can be formed to reach the quota, whether it be a 50% majority or a 2/3 majority, has to go through that person. And so really what the banzaf lawsuit was all about is that weighted districts shouldn't be weighted proportional to the population, but rather the population should be proportional to the power wielded by the individual legislatures. Next slide. So the banzaf index is a probabilistic interpretation, right? So it's proportional to the probability that in a given member will end up being the swing vote in a given vote, should all the rest of the votes stay the same. The term critical count is basically the number of coalitions that could be formed whereby that individual member would have the swing vote. So in calculating the banzaf index, basically all possible combinations of the legislators, voters, or members are calculated, and then given the proportion, they're given it's given the probability that that person is going to be the swing vote. So the banzaf index itself is the number of times that vote could be critical and divided by the total number possible of coalitions. No perfect solution is likely to exist, right? So you might, there is a long shot possibility that there is actually a perfect solution, but most of the time you're shooting for close enough. The goal is basically to reduce the deviation in between the normalized banzaf score and the population proportion that the member represents. And I'm going to go into that a little bit in future slides. I'm going to get kind of in the weeds here, but I think that it's important to kind of see what this is and how it works. So the important thing to remember through all of this is that you're calculating the proportional power of each member. Next slide. Okay, so what we're looking at here is some sample data of a weighted voted system. You've got 9 districts. This is the 2010 after the recalculation. This calculation is based on a simple majority vote. All right, so I've got the quota down at the bottom left-hand corner. That's 163. That means for anything to pass by a simple majority, you would need to achieve 163 votes. You can see that we've got the population and the population proportion of each district, and then the weighted vote that was assigned to those members, the critical count, which is the number of times that that member could be a swing vote given all the combinations of coalitions, the banzaf score, and then a percentage discrepancy between the banzaf index score and the proportion of the population. The other thing that I have there is the absolute deviation of that discrepancy, and I added that to this chart to be able to use it as a sort of metric as to how close a given weighted vote sort of scheme comes to proportionality. So if I were to compare this to a different weighting, I could add up the absolute deviation between the banzaf index score and the population proportion. And if that number is lower, then I know that I've gotten something closer to a perfect proportion. The one thing that I find interesting here, and I'll go into this in the caveats at the end, is that generally we have pretty low deviation, except for in 3 districts here, we have 13%, -10%, -9% discrepancy or deviation between the banzaf score and the proportionality. That's most likely due to a compromise, because the weighted vote count has to basically split the difference between proportionality, both in a 50% majority and a 2/3 majority. Next slide. So this is basically what you would look at in this weighted voting system, looking at the 2010 weights using the 2020 population numbers. So interestingly enough, the absolute deviation decreased a little bit just because of the population changes, but you have that -10 and 10% discrepancy there, and so we would look at recalculating the weighted vote to see if it can be made better. So next slide. Okay, so this is an example recalculation. The first thing that I would draw your attention to is the total absolute deviation there at the bottom right-hand corner. You can see that it dropped by by over 10% in this recalculation. So the weighted votes have been readjusted here, and I have another slide to show the differences between them. And the banzaf index score is recalculated. And you can see the discrepancy here. These percentages are much lower than they were in the previous slide, which is what leads to your decrease in the absolute deviation there. Now, one of the things that next slide, I actually get into that later. Next slide. Okay, so this is the 2020 proportional vote versus the weighted vote. So if you look at the proportional vote, the third column from the left here, that would be what your weighted vote would look like if you were basing it on the population proportions in the column to the left of that. And the weighted vote column there is the recalculated weighted vote. And so you can see they're not like super far off, but they've definitely been readjusted in order to be able to get you where you need to go. And if you look at the discrepancies and the absolute deviation of simply the proportional vote, you can see that this is almost 20% higher. The absolute deviation is almost 20% higher than it was in for the banzaf index for the weighted vote. So next slide. So a couple caveats of this example. This wasn't a full sort of recalculation of the weighted vote scheme. So this example only took into account a simple majority vote. An actual recalculation of the weighted vote would also consider the 2/3 majority scenario, and then find the best solution that applies to both scenarios. In this particular example, I kept the quota, or the number of votes that would be needed for a majority, the same as it was in 2010. An actual recalculation would also consider an alternative number of total votes in the system, and thereby changing the quota. And the third one is the biggest one here, is that there's not a simple formula that you can plug the numbers into and derive, the optimal weighted voting. To calculate the weighted votes, you actually have to back into the problem from reverse, because of the way that the banzaf score is calculated. You both need to look at your individual discrepancies and the total absolute deviation. And there's a few things that can change your banzaf index score drastically. Anytime you change one member's vote, the banzaf index for everyone else changes. Anytime you lower or increase the quota, the banzaf score changes drastically. And so part of this is trying to figure out, what total number of votes and what quota will be able to derive you the most flexibility in being able to achieve lower deviation between your index score and your population proportions. And then the other part of it involves, basically hitting a moving target, because every time you change one of your weighted votes for one member, it changes the banzaf index scores for everyone. And so there's definitely a trial and error process which needs to be done. That's one of the reasons that the absolute deviation is a very useful metric, because if you change one small thing and all of your banzaf index scores change, you can just a quick back of the napkin thing is you can look at that absolute deviation and see if it went up or down, and then you know which direction you're moving in. So and you're constantly trying to lower that number. Next score, or next slide. So this is for more information on calculating the proper weights. There's a technical report, January 1982, that goes into some of the process and math on that. And then we're also available to be able to answer any of the questions that you might have, and our contact information is right there. And I believe that concludes the presentation.
Thank you very much, Josh Simons and Jerry Benjamin and Jeff Weiss, for your time and expertise. I'm going to start taking questions, but the good news about this is we have to do it only every 10 years, and the bad news is that in terms of weighted voting and some redistricting conundrums, the bad news is we do it every 10 years, so we have to rethink or remember how it was done before. So, and now we have a new law to take into consideration. So we appreciate your expertise here, and certainly these gentlemen are available for questions right now. And then if you have a follow-up afterwards, we're providing their contact information. So let's get to the questions. First of all, if you have any questions, please submit them to the questions panel on the right side. At least it's on the right side of my webinar panel. But so I invite you, if you haven't already done so, to submit a question there if you have one. The first question is for Jeff Weiss. Jeff, can you go back and give us the first handful of criteria that must be considered by your redistricting team?
Okay, sure. The first criteria will always be one person, one vote, that each district has to be equipopulous to all other districts. And under the new state law, that means that the size of the smallest to the largest district cannot differ by more than an overall deviation of 5%, or minus 2.5% or plus 2.5% from the ideal population district size, or plus 4%, minus 1%. But it can't be plus 4% and minus 2%. That goes above the 5% limit. It would take you to 6%, which is now impermissible. The old standard used to be 10%, but New York has chosen to go narrower. The second criteria is minority voting rights, that you need to take into consideration your minority communities. And then the third criteria, districts must be contiguous, so you can travel from one part of a district to another and not leave the district. Districts should be compact, meaning not necessarily square, rectangular, or round, but not a 75-sided Rorschach test. You want to also consider an array of other criteria, not favoring or disfavoring incumbents, particular candidates, or political parties. Next, that you can consider existing district cores, political subdivisions, and communities of interest, which are where like-minded people define where they live, how they live together, and how they ought to be districted together, a rather subjective test. And then also, and very importantly, that no village, towns, or cities, except those with at least 40% of a full population of a single member district, should be split. And these criteria are in ranked prioritized order, something that the state criteria for the state legislative and congressional redistricting were not. So you want to be mindful and take a look at the law, I'd be glad to you contact me, send you a list, or send you my slideshow deck so you can see this for yourself, or just check the new municipal home rule law. It's all been codified.
Okay, great. Thanks. So one follow-up there. So communities of interest and minority voting or redistricting based on race. What's the difference and the similarities there, or how should those be considered?
Well, race breaks out two different ways. One, if you have a large enough Black or Hispanic or Asian American population that could comprise 50% plus voting age population of one district, and if you bring in a specialist to determine whether you have, in fact, a high level of racially polarized voting, you'd be required to create a minority district. That's under Section 2 of the Voting Rights Act. Then you have the 14th Amendment, which bans racial packing. That's where you purposefully increase the minority population of a district beyond that necessary, let's say under a Section 2 test under the Voting Rights Act. But here we have a packing issue where you're putting too many minority voters into one district, where, let's just say, they could elect their preferred. They can elect their preferred candidate at 51% total population of the district. Voting age population. That you draw the district at 60%. Well, that additional 8 or 9% can go to help elect the Black community's preferred candidate in the other district. Now, communities of interest could be simply a community. Let's say a college campus community, or an area with hospitals, a medical community. It could be a shopping district where people share similar values living in a downtown area. A community of interest can also be a small, compact, naturally occurring minority community as well. You know, there's no one size fits all here, but you want to make sure you're properly districting minority voters. You also, more or less, regardless of whether you have the Voting Rights Act tests I just laid out, but if you have a small area of minority voters who have very similar socioeconomic shared interests, then there's no problem with simply keeping them in a district together.
Great.
It really involves a case-by-case analysis in many instances, and I'd be glad to discuss specific situations with people later on.
Yeah, it sounds like it definitely is a case-by-case interest. In one case, and you referenced this, is well, this is a two-part question that Josh answered already in the panel, but I want to ask it for everybody. One is voter turnout a legitimate factor in local redistricting? And Josh's answer is no. Voter turnout is not a factor in redistricting. And then his follow-up to that is our city has a very large student population with very low turnout in both presidential and local elections. Well, you just referenced student, like a college campus, as perhaps a community of interest, but then it's a community of interest that might have a low voter turnout. So can you talk about that a little bit?
Well, yeah, that's also a very case-specific situation, because you have some college campuses in the state where the campus student body is active in electoral politics and community issues. I've also seen recently in one county where the student population is not active, and I think a survey of resident assistants living in dorms said, we don't care if our campus is divided into two districts or not. So again, there's no one size fits all. Some campuses may be very well organized, and others may be not organized at all.
Okay, thank you. Does the law require districts that have been historically divided up by town boundaries to be redivided along different boundaries, splitting up a town? We are a county with a legislature and weighted voting system. However, some of the districts may deviate above the 5% of the ideal size district.
Well, Josh might want to weigh in here as well, or Jerry, but you've got to keep the deviation below the overall 5% limit. So if you're using townships now under the current lines, you're going to need to be sure you might end up having to split a town to comport with the 5% limit. The courts could allow an exception if it's very objectively uniformly applied for a specific circumstance. Rarely, but occasionally, courts do allow for differences, but that's an exception. I wouldn't recommend it at the start.
Okay, thank you. This from another area. How are jails taken into consideration, or jail populations or prison populations in the redistricting process this year?
That's a great question. Under a 2010 state law, all governments in New York are required to reallocate prison populations by taking the prisoners in state or federal prison locations and reallocating them to their homes of record prior to incarceration. Now, the New York State Legislature's LADFOR, the Legislative Task Force on Reapportionment and Demographic Research, has already determined that population reallocation. They went ahead, identified every person incarcerated in a state prison. Federal prison information is not made available by the federal government, so it really doesn't apply and isn't reallocatable. But the state prisoners have been reallocated from their county or from the prison site where the Census Bureau counts them back to the census block of the home of record prior to that individual's incarceration. And those data files are available at the LADFOR website in shapefile downloadable format. So you are required to use that database when you redraw your district lines.
Just to follow up on that, because there has been some confusion about this, is that just for state, Senate, and Assembly districts and congressional districts, or is that also for the counties?
It's for every government level in New York State.
Thank you, Jeff.
And most municipalities and counties, to my knowledge, did do the reallocation in after 2010.
Okay, I think Josh took a stab at this, but I'm going to ask this out loud again. Are municipalities required to consider the banzaf score in redistricting? So not for redistricting, but weighted systems, right, Josh? So if a county uses a weighted voting formula, they have to use the banzaf score. Do any municipalities use weighted voting?
Not to my knowledge. I mean, I'm sure that there's some, because we have pretty much every form of local government in New York, but I haven't actually run across one that does.
Okay, thank you. Can you share the link to the latest best population numbers that are to be used? Just want to confirm we have the best numbers to use. And this is a question that we've gotten too. So some counties are going to the census website, and there's also data available at Cornell, and there's also data available through the LADFOR website. So which is the data that our county redistricting committees should be using?
I'm about to link it.
Okay, great.
So it's the LADFOR prisoner adjusted population data. I just answered that question with the link to the page on LADFOR's website.
Okay, so the LADFOR website. Thank you. Can potential future growth in an area be a factor in redistricting? That's a really good question. So if there's an area that's about to have new jobs or new growth or a new development, should that be a factor in redistricting?
I'll take a stab at that answer. You have to use the data that's reported by the Census Bureau in the 2020 decennial census data report. Now, if you remain within the 5% population deviation, and if you consider the community of interest criteria, you could conceivably include a growth area that, let's say there's going to be a hospital built on a vacant plot of land with adjacent housing. You might want to include that piece of land in a district with similar characteristics, but you cannot incorporate the estimated or predicted numbers of people into your database. You cannot do that, but you have to work within your population deviation and your communities of interest sense of, how to create the districts, and that could be a factor, but there's no data available to use that could be added to your database.
Great, thank you. And to answer a question on whether there has been a challenge to the new redistricting law, there has not been a challenge that we know of at this point. Are boards of supervisors required to consider the banzaf score or similar method in determining number of supervisors and weighted vote system? This could be for boards of supervisors that have representatives in a city or a town, or multiple representatives on the board of supervisors. So are boards of supervisors required to consider the banzaf score in determining the number of supervisors?
Yeah, so no. The number of supervisors doesn't really enter into the equation. The banzaf score is used for weighting the vote of the supervisors. My understanding is that the number of supervisors is a local choice external to that. Of course, if you change the number of supervisors, then you're going to change all of the all of the banzaf scores, and the weighted votes need to be recalculated, because certainly that's one thing I neglected to mention, is that if you change the size of the body, then all of the banzaf scores change.
Great.
Is the number of supervisors specified in the local law or in charter? Where is it specified?
That's a good question. It wouldn't be in the charter. In that case, it's Saratoga County, so it must be in the local
Charter. There's no charter, so it couldn't be in the charter.
Right, so it must be in the local law, but we'd have to double check that. In the hierarchy of ranked interests, does community of interest apply, and what determines a community of interest? We've covered a little bit of this. So community of interest, Jeff, you said was halfway down or in the middle of the ranked criteria.
Well, yeah, communities of interest are ranked in the same paragraph as considering cores of existing districts, political subdivisions, favoring or disfavoring incumbents. So you've got to read them one sentence after another, and communities of interest falls at the end of that list.
Thank you. Since boards of elections apply the redistricting data to the voters and need to work with the departments of information service tech departments, would you recommend committees use software, shapefile data to create boundaries to give the Board of Elections a product that can be accurately applied? Josh took a stab at this.
The inclusion of boards of elections or election administration in the law is a idea responsive to the difficulties that boards of elections have had with the timing of the process and its outcomes in acquiring proper facilities and personnel to run the elections and to make the changes and inform citizens of the changes where they might be voting. So I think the maximizing the collaboration would be a very good idea.
Mark, can I add one last comment on the question about future developments?
Sure.
One thing that's sort of critical about housing or construction that's underway or being planned is that every county needs to be mindful of the need to keep track of demolished housing, new housing, any residential development that's being planned in advance of the 2030 census. I know it might be early to look at 2030 now, but one of New York State's biggest challenges at the end of the last decade was to work with the Census Bureau under the LUCA, the Local Updated Census Addresses Program, to identify housing addresses that the Census Bureau did not have in its master file. I know the state scurried at the last minute to try to do it for a lot of counties, but it's something that I've discussed with Governor Hochul, with Secretary of State Rodriguez, and I'm hoping to develop a program to involve everybody in the census more regularly, because we can't wait until 2028 for 2030.
Thanks, Jeff.
Mark, on
So
that, Mark, on the question, when you get a moment, on the question of communities of interest,
go ahead, Jerry.
what's important about this is there's litigation that says that certain groups are not protected minorities under the Voting Rights Act, so that this gives them potential sway in the redistricting process. In particular, a case I remember from back in the 1980s involved, and maybe Jeff has detail on this, involved a Hasidic community in Brooklyn. They wanted to be considered a protected minority, but the Supreme Court did not agree with that idea.
Right.
Now,
Yeah.
under communities of interest, they can make a claim, although it's not a highly ranked criteria. It's relatively equally ranked with existing municipal boundaries, however.
Yeah. That actually came into play last week in the assembly lines. In the town of Ramapo in Rockland County, the Hasidic Jewish community was divided into 2 or 3 assembly districts. And as a community of interest, they wanted to be contained in, I think, 1 or 2 districts, and they were able to achieve that goal. The 1974 case dealt with the Voting Rights Act, where in order to create new minority districts, the Hasidic community in Brooklyn had to be split, and the court ruled that religious communities are not protected the way racial minorities are.
Okay, great. Thank you very much. I'm going to just keep on going here and answer the ones. I appreciate Josh has answered several questions on the panel. So if you take a look at those, if you are able to, if you open up your questions panel, you'll see answers to most of these questions. Can you restate the concept as practicable? It kind of means if you can, you have to. So if it is practicable, you have to do that.
That is correct. And
okay.
I often go just to the online dictionaries and reassure myself, but practicable means if you can do it, you must do it.
Are counties required to engage a racial block voting analyst? Is this a best practice? Is there a list of qualified analysts who perform that assessment?
Well, it's not, this is Jeff, it's not required, but it's a smart thing to do if you have a large minority community where you think the either all Black or all Hispanic or all Asian, the law does not at this point require coalitions of Blacks and Hispanics, although I do think it's going to be tested in the courts this coming decade. But if you think that you are in a situation of having a racially polarized voting situation, I'll give you one example. In the last 10 years, Albany County lost a Section 2 Voting Rights Act lawsuit for the failure to create adequate minority districts in Albany County. So if you know your own counties, if you think you've got a large enough minority population, and if your sense is that there's been polarized voting, then you'll want to engage a qualified political scientist. It's not a requirement, it's just a smart thing to do. And if you don't do it and you're sued, you'll have to do it later. But there is no a list of recommended experts. They're in very high demand right now, and if you think you're in that situation, please contact me, and I'd be glad to refer you to 1, 2, or 3 people that I know and have worked with that can do that kind of work.
Okay, rapid fire here. To be clear, adjust the weighted vote to match it to the raw population or using the power index. The answer to that is using the normalized power index score as close to the population proportion as you can make it. It appears that there's a very fine line between dilution and packing of minority communities, and the answer to that is yes, there is a fine line there. The MHRL defines population shall mean citizens, residents, or registered voters. Does this mean you can choose to use a count of citizens or registered voters instead of a census results as the basis of redistricting? The answer to that is please use LAT4 prisoner adjustment population data. It is required by the new state law. Do we use VAP percentage or raw percentage in drawing lines? The answer to that is raw population to draw the lines, VAP for the Voting Rights Act tests. We are a county legislature with currently no weighted voting. We just went through a full board election. Can we enact weighted voting with existing district lines until the next scheduled board election?
Well, this is Jeff. You've got to redraw your lines to comport with the new census data before your next election. Depending on your county, and if you're a charter county, you could always amend your, Jerry, correct me on this, but you could always amend your county charter going through that process, which usually takes a bit of time to change your method of electing candidates. And you also want to be mindful that if you have a minority population that where you're concerned over minority voting rights issues, then weighted voting, anything but single member districts might not be advisable.
Yeah, this is a county.
I would have to look at cases, but remember that we had weighted voting as an alternative because we didn't want to change existing lines. And there's a strong case for not changing existing lines, that is town or city lines, as citizens are used to them, make strong connections with them, and it maintains a level of simplicity that helps with access and one would argue might help with turnout. So I have to look at the cases where legislatures are using weighted voting.
Yeah, this is Allegheny County that does not have a charter, and their next full board election is in 2025. So the question is what to do between now and 2025. So it sounds like we need to maybe take this offline, Brooke Harris, and I'll connect you with our panelists here.
That's a good idea.
Cayuga County uses weighted voting. So this is a legislature, Cayuga County, and they use weighted voting. So then the question that Trish asked above is, are counties required to engage in racial block analysis? What's the other question? Are municipalities, so is Cayuga, which is a board, legislative board, required to consider banzaf score in their redistricting? So they wouldn't be redistricting, they would be reweighting. How does that work?
All right, so if they're not redistricting and they're reweighting the vote, then yes, they have to use the banzaf score. If they're redistricting and drawing the lines, you don't need to use the banzaf score. So there are three ways that counties comply with the one person, one vote, equal representation standard. The first is to redistrict, to redraw the lines so that roughly equal populations exist in each district. The second way is multi-member districts, whereby you adjust the number of members from each district to be proportional with the population of the district. And the third way is the weighted voting, whereby you change the weight of each member's vote to so that the power index is roughly equal to the population proportion.
Could I understand the rationale for changing the lines and then using weighted voting as well? What's the reason for that?
I think that the person who's using redistricting is sort of a catch-all for achieving equal population. I don't think that they actually meant that they were going to be changing their lines. If you were a weighted voting system and you wanted to change your lines, you would change the lines first without consideration of the weighted vote for whatever reason that you wanted to do that. Maybe you wanted to include, maybe you have a village that's split between two towns and you want to include all of that village in one town and it's not currently the way your lines are drawn. I don't know. But you would do that change and then you would get your populations for each one of the newly drawn districts and then you would recalculate your weighted vote. So in the instance that you had a weighted voted system and you wanted for whatever reason to change the lines of the districts, you would change the lines without using whatever criteria that you wanted to change the lines in the first place, and then you would recalculate the weight based on the population.
But essentially, you'd be changing the lines, but not conforming to the requirements of the law, and then bringing yourself into compliance with the law by weighting the vote.
Okay, great. I'm going to move on here. There's another census expert on the line that is attending. It's Jan Vink. If a group quarters is counted in the wrong block and a count question resolution is filed to correct that, can the local governments use corrected counts for redistricting, even if the correction is not yet published by the census?
Well, my experience is that if you have incorrect census data, or let's say people counted in the wrong place, you can move people around as long as you do it in a uniformly objective manner that you can explain. You're not wedded. You're as Josh indicated, you should use the data downloadable from the LAT4 website. But if there are local situations where you need to move some people around, the census count resolution process does not make changes to the PL94-171 data. That remains the same, but you've got to be able, for any changes that you make, justify them. I've done those kinds of changes myself, not in New York, but other states where I've moved dormitories from block 1 to block 2. I've redivided military-based housing, but I did it in a uniform, objectively understandable method.
Yeah, so in this instance, what I would say is that if you have a CQR challenge out there where you basically have submitted a solution to the Census Bureau for a miscount in the group quarters, I would use the resulting data from the CQR challenge, in other words, the solution that you provided to the Census Bureau, in anticipation of it being accepted and published. It won't change the PL, as Jeff said, it won't change the census redistricting data. They don't reissue any of that, but I would go ahead and use that. And then if for whatever reason the challenge is rejected, then I would fall back on using what was published in the LAT4 data, which is, a modification of the PL data. But for the most part, I've not seen a CQR challenge that was submitted to the Census Bureau in New York that hasn't been eventually accepted.
What is the limit for divided towns, 110% of district population or 40% of the full ratio, or both?
That's now superseded by the new law. It's 40%.
Okay, 40%, superseded in the new law. Are there are plans of redistricting that include multi-member districts required to go to a weighted voting system?
But you're not required to. These are options that, as long as you're comporting with the law one way or another, you could change your local system. Just the caveat, again, be mindful of any kind of minority voting rights situations and anything but a single member district scheme. Josh or Jerry?
Multi-member districts draw particular attention from because of concerns about the Voting Rights Act violation. So that's something you have to be heads up on. Additionally, you have to be within the limits of deviation from the mean district size by dividing the number of members in the multi-member district into the number of people into the population and being within the range of acceptability.
Let me just also add, just to be clear, if you if you're in Erie or Onondaga or Monroe or Albany or Rockland, Nassau, Suffolk, Westchester, New York City, there you've got sizable minority populations and are likely to want to explore doing racial voting analysis. But if you're in a county with a relatively small minority population of, let's say, less than in the 10s, 20s, 30% range, then you are not going to really be dealing with polarized voting unless your local districts are set up in such a way where there's, let's say, you have a city with a large minority population that could be 50% plus of a minority district using the ideal size. I just want to be realistic that larger counties with minority concentrations need to think of this less urban counties need to think of it only if you have very concentrated pockets of minority population where a district could be created. So I don't think all of you need to do this racial voting analysis, but some of you may have to.
Okay, thanks for everybody for sticking around. It's 11:17. I've got one more question we're going to end on. This webinar has been recorded and it will be available on our website later this afternoon. If you want to refer to it or send it to anybody in your county or your colleague across the state who may be interested, plus the information of these gentlemen is available. Their contact information is available. And if you can't find it for some reason, please let me know or Jeanette know, mlevine@nisac.org. The Benjamin Center slide titled Caveats of this example included a statement that stated a weighted voting calculation would balance simple majority and 2/3 minority scenarios. Here in Ontario County since 1968, we have always maintained two separate weighted voting allocations, one for simple majority and one for 2/3 majority. We've never combined the two. Are you recommending this combining of the two? And if so, why? And the answer, Josh?
Yeah, so no, having two weights is better. I should have been more clear there. What I think was going on in the example data that I showed was that they had combined the two to find a best fit between the two of them. And the reason I say that is because the 2010 weighted vote numbers didn't make a ton of sense to me. I could fairly easily, draw a weighted voting system that could achieve lower deviation than the one that they used in 2010. So my suspicion is that there was some kind of compromise going on between the simple majority and the 2/3 majority. Best practice would be to have a different weight depending on what the quota or threshold for the vote would be, if that would be achieved basically by changing the quota and running the banzaf scores again, and then manipulating the weighted votes of each members to achieve the lowest deviation between the banzaf power score and the proportional population. So no, the way that Ontario County is doing it is best practice. My suspicion is that something was going on. Either the weights were improperly calculated in 2010, which I'd like to believe didn't happen, or there was some kind of compromise, such as splitting the difference between the majority and the 2/3 majority. That is not best practice, the way that Ontario County having two separate weights is.
I agree.
Thank you, Josh, from the Benjamin Center, and thank you, Jerry Benjamin from the Benjamin Center, and thank you, Jeff Weiss from the New York Law School, and thank you to Jeanette Stanziano, NISAC's Director of Education and Training, and thank our members for attending this webinar on redistricting and reweighting voting systems. That'll be it for us today. Enjoy the rest of your day.